Well, hello, everybody. This is Dennis Block with another edition of Zoom Landlord Tenant Radio, coming at you every Saturday at 3 p.m. I want to start by telling everybody that anybody who attended the Apartment Owners Association trade show, we had just a great event that was last Wednesday. The crowds were crazy, and I really appreciate all the people who came up to me who said that they're watching my Zoom conference on Saturday. So it was very heartening to see how many people are actually tuning in and then actually walking over to me at the convention center. So I do appreciate that. I did want to start by saying that the song that you heard, and of course, we know I'm a very old guy, was back in the 60s, and it was by a group called Crosby, Stills, and Nash, and the name of the song was Sweet Judy Blue Eyes. And quite frankly, ladies and gentlemen, I do have blue eyes, in case you didn't know. So I wanted to kick this off today by talking about a couple of things before we open it up to questions. And that deals with renting out your units and trying to get a proper tenant who's not going to be the subject of an eviction with my law firm. And while there is, of course, the standard credit checks, which you can get from the apartment associations, and making sure that you check their sources, there's other things that you might want to consider. Would you want to take a tenant who has great credit, great references, but sued the last 12 landlords that he had? So you see, it's not just the fact that he has great credit and good references. You want to know a little bit more about him, and that's what we call a civil litigation check. You can do that by going to any of the websites for any of the counties in California, the Superior Court, and doing a check, what they call a plaintiff defendant check, to see if this person, this applicant, has either been a plaintiff suing people or been a defendant and being sued. And that might change your position of whether this is a proper applicant or not. I've talked about this briefly with Jeff Fowler from the Apartment Owners Association, and I think the association will be instituting this in the short future. So again, you can kind of do this on yourself by checking to see what lawsuits. Now, people say, well, we do an eviction check and that should show. But the problem with the eviction checks are that based on the laws in the state of California, which are only in favor of tenants, they actually mask or seal records of evictions for tenants. That's right from the beginning filing. And unless you obtain a judgment within 60 days, those judgments are totally hidden. Even though the guy was guilty of unlawful attainder, you had to evict him from multiple places. If you can't get a judgment within 60 days, which is very difficult to do, then his eviction record is going to be sealed. You're not going to, if you do an eviction check, you're not going to know. So you want to, in these situations, have as much information as you possibly can. And one of that would be this litigation check to see not whether he's been part of an eviction case, but whether he sued his last landlord for mold, or whether the last landlord sued him for damage to the property. So these are the types of things that you want to check. One other thing, and my son, our firm obviously does collections, and my son also clued me into another way that you can check, and this deals with stolen identity. If somebody comes to you with a great credit score and great references and everything else, the problem with that is that you don't know whether in fact the person in front of you is actually the person who is name appears on that credit report. A lot of times people are giving phony driver's licenses, phony credit reports. It's difficult to tell. So you don't know whether the credit report that you're running is tied to the actual individual that's in front of you. And believe me, it is so easy to get a phony driver's license with their picture and their name. But there is one thing that my son clued me in on, and again, we're going to be discussing this with the Apartment Owners Association. There's one way that you can really tag whether somebody has been a subject of this phony identity where they've stolen somebody else's identity. And that is, we do a check on their cell phone. Now, they're going to have to give you their correct cell phone. Because obviously you need to contact them to tell them that you got the apartment or you didn't get the apartment. Well, we can run, I know we do it at our office for credit purposes when we're trying to collect on a judgment that we've obtained, but we've done it. And what we find out is when you run a check on a cell phone, just to put in that cell phone number, you can tell who it belongs to. And trust me, if it doesn't belong to the person whose credit you're checking, that means this person is trying to steal someone else's identity. So that's another trick that you might try in terms of being on your game to make sure that you're not subjecting yourself to somebody with stolen identity. And trust me, when we do collections and we get a judgment, and it's already at the end of the case, and we have no way of knowing because obviously we're not involved in leasing out the unit, our clients are, and we'll come up with the fact that this judgment really was not in the name of the actual person who lived in the unit. So anyway, be careful on that situation. That's my preaching for today on March 23rd. And I'm going to open it up to questions. Remember, if you do want to ask me a question, very simple, please electronically raise your hand. You can do so by looking at the toolbar, generally on the bottom of your screen. It'll say raise your hand, and I'll know that you want to be called on. Please do not speak unless I ask you to unmute yourself. And also understand that this Zoom meeting is for informational purposes only. It doesn't take the place of quality legal help where you're actually hiring an attorney. But again, we try to do our best to answer your questions. I'm going to see if I can get through everybody today. And I'm going to start with our favorite, Dina. I'm going to ask you to unmute yourself.
Hi, Dennis. How are you?
Hello, Dina. You're
Hi.
top of the list, young lady.
Thank you so much. It's always good to thank you for sharing your wisdom with us. That's really appreciated. And I have a question because before I know from you that, when we have a lease agreement with the tenant, we're supposed to put our physical address there in case they want to serve or something illegal. But is that okay for us also to put in the lease agreement? Because some of the lease agreements, like especially from the realtor of the car, they put they are supposed to forward and they're supposed to, when they leave, to give you their forward address. But most of them nowadays, they give you like a mailing box. So can we put in the lease that we want the physical address as well as the mailing address, or we can't, or it's only the landlord has to serve that? That's the first question.
Okay, well, first of all, if your tenant is living in your property, then you would know the physical address upon which to serve them.
No, but when they leave, this is because there's a clause saying when they vacate the unit, they need to forward their address, but they didn't say which address. And most of them, Dennis, when they do, they provide you like a PO box somewhere.
Well, there's no reason, you can certainly put that into your rental agreement, but of
Okay.
course, if the tenant violates it, what are you going to do in that situation?
Yeah.
They're just going to move out. They're not going to tell you where they're really moving to when they move out. So I don't see that as a necessary thing.
Okay, and only one question also. There is that when we had back then in 2019 the AB 1482, there were some disclosures that we have to put in 2020 at certain point if we have a lease. Now we have this new law about relocation, I think, which is effective the 1st of April. So any lease after the 1st of April for the laws that enacted, which is so many by state, by some of it county or something, are we supposed to give do you know any of those that we have to submit a disclosure, like saying, hey, this property is exempt from this, or if it's
Well, I think if you use the same language that we already did, that this property is exempt from statewide rent control, I don't think you have to have the new code section in that, but we'll wait to see how the laws are actually drawn up. But
okay.
I don't think, as long as you're informing the tenant that it's not under statewide rent control, I think it's
So we
fine.
can say like this disclosure, and we check the mark which it says this property is exempt. That's enough, right?
I'm sure that is enough, Dina.
Okay, thank
Anyway,
you so much. Thanks.
thank you, Dina. We're gonna move on to, let's move on to Jason Taylor. Jason Taylor, I'm gonna ask you to unmute yourself.
Hey there. So picking up on your thing about checking people's records on the court and stuff in the application process, what if I had, told someone that, they need this for their credit score, they need to make this kind of much money and all this stuff, but I didn't say anything else. And, he checked out, good every other way, but then I did a court check, or I didn't like one of his references. Can I still deny him if I didn't tell him up front?
And the answer is absolutely. If you find out something about this person, that he's like sued the last 3 landlords for habitability and cashed in $100,000, whether you had that as your stated policy or not, that's a reason to reject the applicant. Don't forget,
Okay.
you're allowed to, this is based on like discriminatory laws, and this is not, you're not discriminating on basis of one of the protected classes. You're doing this for an economic reason, and that makes total sense to me.
Okay, thank you.
All right, let's move on. I see an iPhone 15MZ. I'm going to ask you to unmute yourself. If you are on the iPhone, you can just
I am, yes. How are you, Dennis? It's Matthew Zarabi. Hope you're well.
Matthew, how are you, sir?
Good. Sorry I missed you on Wednesday. I was really looking forward to it. Couldn't make it though.
Well, you got me today.
Thank you very much. So my question is regarding the issue of tenants storing a lot of items on their balconies despite notices. So now it's getting to the point where I'm having to consider writing a stern letter with coupled with a 3-day notice. And then I wanted to see what my rights would be at that point. I mean, after all, it's a zoning violation. LAHD said specifically, do not store any items on balconies. In the lease, it specifically states the only thing permitted on balconies is patio furniture, 2 chairs, and a small table. And actually, inspectors came to them 2 years ago, told them this. So now it's becoming a public safety thing. In inclement weather, things can fly off and hurt people, public safety issue. And I got to get serious now. I want to assert my rights. What can I do now?
Well, I think it's clear that you have it in your rental agreement. You're telling me that this is the law for that jurisdiction. So clearly you would want to serve a 3-day notice to remove these articles. I don't think you need to write a letter at this point. You've already had this discussion. So I would do a 3-day notice to perform or quit, giving him 3 days to remove those unapproved items. If the items are still there, take a picture of it, and after the 3rd day, so on the 4th day, and then proceed forward with an eviction.
Okay, now the thing is this, I always wanted to understand this. Like if you hire a lawyer and then you proceed with the eviction, and now all of a sudden they get served with the process server, then they decide to take the thing off, the stuff off the balcony. Is it too late? Can I still accept rent from them?
Okay, well, number one, whenever you serve a 3-day notice, be it a 3-day notice for rent or a 3-day notice to perform or quit, after the 3rd day, you're not taking any rent. That would ruin your case.
Got it.
That's number one. Number two is the question I thought you were going to is that, hey, so I didn't get it off in the 3 days, but you know what? On the 10th day, I did remove all the items, so everything is perfect and life goes back to the way it was. And I always say to people like that, look, this is a 3-day notice. It's not a 3-day plus whatever the hell I feel like. It's a 3-day notice. If you don't get your rent within the 3rd day, and as I told a client who rejected it, the rent on the 6th day, I said, we don't have to accept it. We can proceed forward with this. And the same thing is true with the storage of items on the balcony, where you've served a 3-day notice. He had the opportunity to just drag it into his house. If he chose not to and now wants to do it on the 7th or 8th day, it's too late.
Okay, so the most important thing is do the 3-day and don't ever cash their checks. You got to send it back to them.
Absolutely. On a notice to perform or quit, I wouldn't take any rent once that notice is served.
Is there any specific way I have to return the rent to them?
Just mail it back. As simple as that.
Terrific. And in your opinion, do you think that you would be successful in an eviction? Because the courts are so tenant friendly, they might say this is not enough to get someone out after you spend all this money and time.
Well, I think that the case would be a very winnable case. And talking about that the courts aren't tenant friendly, I tweeted that this last week, we actually on Thursday
Won 2 jury
two
trials.
jury
Yeah.
trials, right? 2 jury
Very
trials
nice.
on the same day by 2 of my attorneys. So you know what? We do prosecute these cases.
Terrific. Congratulations on those. I appreciate it. I'm going to send out those 3-day notices on April 2nd. Let me get the rents and then we'll give them the 3-day notice right after.
You might want to wait a couple of more days.
Couple of more days. You got
Yes.
it.
All right,
Thank
take
you
care,
very much,
sir.
Dennis.
Okay, we are moving on to Lynette Austin. Lynette Austin, come on down by unmuting yourself.
Hi there. I was in court on Tuesday with Sherman. And
We
we
don't
had,
talk about specific cases. So if
okay,
you have a general question, I'm happy to answer it. Otherwise, you need to call the office, young lady.
got it. So that I will do.
All right,
Thank you.
thank you. Okay, let's move over to Janice Lignetto. Please unmute yourself.
Hi, Dennis. A lot of headlines lately about squatters.
Yes.
I see California cases. I had a squatter when I was away for a week working on my property a couple of years ago in the garage. Fortunately, that was not habitable, so we got him out. I had a property manager tell me recently that the only reason he got a squatter out in a Sacramento house was because it had no working refrigerator. The squatter was subletting rooms to other tenants. On the East Coast, somebody was just murdered by teen squatters. And homeowners who had just purchased a home couldn't move in because of squatters. Is there litigation going on to get rid of this ridiculous squatter?
Well, I think they passed a law in Florida, which was a very progressive law stating that the landlord has the right to ask the police to remove anybody unless they can show that there's a signature of the landlord on a rental agreement, which of course they can't, because they just make up these rental agreements and then tell the police that, hey, I rented the apartment from this person. So, but in the state of California, it's so tenant friendly. Now, at the last show, someone talked about, I think it was AB 602 or Senate Bill 602. And I took a look at that, and it does state that you can serve on your local police department a declaration that the place is vacant and that anybody who goes in would be trespassing. That goes for 30 days. I don't know how many people really are going to think to do that. And then you could technically get the police to come out there, assuming the police know the law, which it appears they don't even know the law. But you could serve that declaration on your local police department. And if anybody goes in, then you can have the police throw them out. I think in accordance with that, if you're really concerned, I would certainly do that. But for the most part, I think it's really up to you to make sure that the premises are locked, especially if you think that they're prone to this type of behavior. In fact, I think it was on the news that right near LeBron's house, that same thing happened.
Right.
So you want to make sure that that house is locked up. I would put an alarm on a vacant house. You can just do it temporarily. And don't do just a regular alarm, which goes to a company. Also do it where it's armed response. Put no trespassing signs up and armed response, so that if anybody does go in before they can kind of quote, take possession, you're already going to have your people there. It might cost you $100 a month, but you want to know something? I think it's worth it until you finally get somebody in there.
Okay, thank you.
All right, Janice, good question. We are moving along. We have a lot of people here today. Lengstra, Bracknell, I'm going to ask you to unmute yourself. Lenska, are
Yeah,
you there?
yeah.
There you go.
Did the Lakers win?
The night I went, the Lakers won, thank God.
Okay, good. In regards to having selecting tenants, if I have an application and everything checks out, and then after the fact, after I approved him, somebody says to me, "Oh, by the way, I have a service dog or a emotional support dog." Can you elaborate again what we need to allow and not?
Well, if they comply with the emotional support animal laws as they exist in California, you have to let them in. The fact that they knew they were bringing in a dog and didn't tell you, it just goes to the morality of the person who you're dealing with. But again, if in fact they comply with the California law, then you're going to have to let them in. So what are the points? Number one, it has to be a letter prepared by a medical professional. I'm not sure what that means, but somebody who has some letters after their name with a comma and then some letters after their name. They have to put their license number, because it could even be like a family therapist, their license number. They have to be located in the state of California, and they also have to have treated the patient, your applicant or your tenant, 30 days prior to issuing this letter. So if they comply with that, then you are somewhat stuck in terms of having to accept this dog. Now, let's pretend you get the dog in there. They had the letter. Everything was fine. By the way, these certificates that say Fido is a service dog, that means nothing. I'm talking about a letter written for their patient, your tenant, which states that they have a disability, and because of that disability, they need the services of an emotional support animal with their license number. But let's pretend they've complied perfectly. And the tenant, of course, goes to work and the dog barks the whole day. In that situation, you can tell the tenant, look, I'm happy to accommodate you, to give you a reasonable accommodation, but this is not reasonable. Your dog is bothering other tenants. So I'm telling you, get rid of the dog. And if you don't get rid of the dog, I'm going to evict you. Now, you can bring another dog in. That's fine with me, as long as another emotional support animal, as long as it's not bothering other people. But if this dog, let's say, bit somebody, or this dog just barks continuously, or you don't clean up after your dog, then notwithstanding this wonderful emotional support animal documentation, you have the right to demand that the tenant remove the animal. And if not, you have the right to bring forth an eviction. Okay?
Okay, and if I meet with the tenant to do a walkthrough and the service dog growls at me?
I don't think that would be something that would be because you're in his territory. I'm talking about where he's disturbing other tenants.
All right, thank
Okay,
you.
Lenska, thank you very much. And now we are moving on to Jim Polina. I'm going to ask you to unmute yourself.
Hey, Dennis. How's
Hey,
it
how are
going?
you?
I
Oh,
wanted
I
to say-
met you at the conference.
I wanted to say to all your listeners, I had a great time at that trade show. It was really worth the 4-hour drive one way.
Oh, well, that's
Absolutely.
good. I'm glad you made the trek down there. And yeah, I think you were in the audience for my seminar, correct?
Yep. Yeah. And I love these seminars. This is a great service you're providing, man. Okay.
Appreciate that.
Ask you for more details on how I can do a plaintiff defendant check and a cell phone number check. I Googled who owns my cell phone number, and it came back National Registry for Domestic Violence Hotline.
Yeah, if
Weird.
the cell phone check generally has to be through a person who does credit checks. I mean, we do that as part of having a judgment, but this is a service that I think all the apartment owners associations should start to institute for that. Also, the civil litigation check, you can go to the, let's say, Los Angeles Superior Court website. You can do a plaintiff defendant index, and they'll tell you how many times this person has been involved in a lawsuit. I think, again, this should be part of a credit check, which I have reached out to Jeff Fowler from the Apartment Owners Association. And hopefully they're going to be instituting this soon, because the more information you have about this, I mean, right now, as we know, come July, we're not going to be able to get a 2-month security. It's only going to be a 1-month security. So, I mean, they're so impacting our basis of leasing out our premises in a safe and business-like fashion that we have to take extraordinary steps, and that would be one of them.
Okay, Dennis, I do have a second question on the unlawful detainer, all the way to the point where the sheriff walk out the tenant outside the house. I assume the sheriffs also remove all of his possessions to the curb as well. What
Yes.
happens to all that stuff on the curb?
So the sheriff has their sheriff moving van. They pack it all. I'm just kidding. The sheriff doesn't touch anybody's personal property. All the sheriff does at a lockout is that they take the tenant who's on one side of the door and put him on the other side of the door, and you change the locks. Based on that, the tenant under California law has 15 days to retrieve his belongings by making an appointment with you up to 8 hours at your convenience. Now, you do not have to keep the personal property inside the unit. If you wanted to, you could move it to a storage facility, or you could lock it up in a garage. And again, the tenant has 15 days to retrieve his treasures. Now, if the tenant doesn't, then you can toss the items away, assuming they're worth less than $700. If they're worth more than $700, then you have to hold an auction on that. And somebody came up to me at the trade show, and the guy who's I knew from the past. So if anybody needs the services of an auctioneer, just call my office, and I'll be happy to give you that referral on that.
Okay, good to know. Thank you.
All right, Jim. Good question. Okay, let's move on to Ashok Madden. I'm going to ask you to unmute yourself and say hello.
Yes, sir. Thank you for your weekly free Zoom meetings. I really appreciate that. My question is, we have a tenant complain about mice. There 2 ladies live there, and we've been taking care of by putting traps. We have a repair, like a handyman, but they say they consulted the attorney, and we need to get a professional company to come and do it because a health issue and this and that.
Well, first, let me correct you on the first thing you said. We do charge for these meetings. Everybody who's in this Zoom meeting gets charged $1,000. So
Okay.
just send me your checks immediately, okay? And I know who all you are. No, I'm just kidding with
As
you.
soon as I get your invoice, I will.
Secondly, look, you can use anybody. It's not required to have a licensed pest control company to do rodent extermination. They just have to do the job. However, as a practical matter, my friend, you're using a handyman to do this job. I don't think that's a good idea. I think you should hire a professional pest control company to set traps, and also, of course, figure out where these rats are coming into, because they're outside. Somehow they're getting into your unit. So I wouldn't be saving money on this situation. What I would do immediately is to get yourself a quality company to go in there.
Yeah, it's just that we have had this situation before, and he's doing exactly what a professional company will do.
If you have faith in him and he solves the job, then the tenant has nothing to say, and his lawyer should have nothing to say.
Okay. All right. Well, thank you. Thank you, Dennis.
Good question, Ashok. We are moving on to a young lady by the name of Susan Vazina. I'm going to ask you to unmute yourself.
Hello, Dennis. Thank you so much
Hello.
for having these calls. Really appreciate it. So I'm a landlord and I'm a tenant, and you've helped me very much in my landlord situations. So I called you probably a few months ago about my tenants that I'm the tenant situation, but I now have a couple more questions to ask about it.
Let me
So-
interrupt you.
Yes.
I just want to know which side is your tenant side, the right side or the left side?
Me as a tenant, I'm on the right side.
Okay, first of all, what city do you live in?
I live in Encino, but it's LA.
Okay, Encino. Is this an apartment or a house?
It's an apartment.
Okay, do you know if the building was built before 1979?
It's not an RSO building.
Okay, so it's built after 1979. These are the questions I'm asking at the office all day long. Okay, so
Yeah.
what's your tale of woe with your evil landlord?
Yeah. So the tale of woe is I've been here 11 years and there's a jacuzzi, and it really hasn't been operating, but we got a notice about 3 years ago. Oh, we got a new heater and it's going to be working. So we were all excited. My kids and I were all excited. And it never was working. I mean, now it's not only is it not working, a new owner came in and wasn't even having the proper things go on, so that now it's turning brown, and then it was turning green, then it was turning brown, and then the mosquitoes were coming. The Department of Public Health came and closed it down, and they still didn't do anything about it. So I called the Department of Public Health. So anyway, the Department of Public Health has been here 4 times, and they hadn't done anything about it. So I wrote a demand letter, because based on 2 laws, one of which I'd like to know where you got it, that if there's an amenity that they stop having, that they have to reduce your rent by the value of that amenity. So there's that for the last 2 or 3 years. And then there's also a law about habitability, that if they raise rent, and there's this habitability issue that an environmental agency or an agency of the city has come in, they cannot raise rent, and they raised rent in September, $160 a month. So anyway, long story
As to that
short,
last point, that law doesn't exist. You can raise the rent. If the place is uninhabitable, then the tenant can withhold rent until such time as the premises are habitable. I don't know that a jacuzzi counts as being, quote, habitable, since it's just a public jacuzzi, but I'll tell you.
okay. I was
But I'll-
going to say it's Civil Code 1942.4 based on California Health Code 17920.3, and it seems to fall right in there. It doesn't have to be in the unit.
Right, but you're talking about a jacuzzi. You're not talking about like, the roof over your head or other things. So I don't think it would be interpreted that way dealing with habitability laws. However, there's something that you can do, which is the first point, is you can make a complaint to the Los Angeles Housing Department that you want a reduction in rent based on the fact that you do not have the use of the jacuzzi. And they will then force the landlord to reduce your rent. I would warn the landlord one more time, saying, look, I want to pay my rent in full. I want to be a good tenant. But you know what? Part of the reason why I rented this unit was to have a jacuzzi. And you have really kind of missed your opportunity to comply with why I moved in here. So I'm going to ask you one more time. If not, I'm going to ask all the tenants to join together and to ask the Los Angeles Housing Department to reduce my rent until such time as you return the service that I was entitled to. I think that's the best way to go, Susan.
Well, the only thing is LA Housing Department won't do it, either because I'm not an RSO, or because it's LA City or something, or that for some reason this unit doesn't fall in.
You know what? You're right. You're right. You did say it's JCO. It's the Just Cause Ordinance, and the other that I was referring to deals with the Rent Stabilization Ordinance. You might want to also try just going to small claims court, and
So that's what I
sue-
was going to do. That's
Yeah,
what I was
go
gonna-
to
that was
small
gonna be my
claims
next
court,
step.
and for the 2 or 3 years, sue the person and tell the landlord, this is what I'm going to do, and I'm going to encourage other tenants to do this. We don't want to do this. What we want is really just to do what you're supposed to do. Give him one more chance, and if the guy still doesn't, then quite frankly, I don't think he's a very smart landlord. And with that, Go ahead.
So
Susan.
even, so two questions. One is, instead of small claims, can I do, deduct from rent?
I wouldn't deduct from rent because that will get you into a situation where they'll serve you with a 3-day notice. Then you're going to have to defend yourself, and you'll probably win the case, maybe, because I don't believe habitability refers to that. So it's better to be on the affirmative
Okay.
than on the defensive. I got to move on, Susan. Thank you so much. And we're going to move on to Miguel. I'm going to ask you to unmute yourself, Miguel.
Okay, hello, can you guys hear me?
I hear you.
Okay, so I just had one question. Can you describe a landlord's responsibility concerning the habitability of a rental property, especially when we've been having like ongoing plumbing issues and like maintenance neglect?
Okay, so you know what, landlords out there, you know, you expect tenants to abide by the laws, and it's also true that landlords have to even be better on their game to provide habitable places, to listen to the tenant's concerns, and if it's a legitimate concern, then it's really up to the landlord to take care of that issue. If you're telling and by the way, what city is this property, Miguel?
Los Angeles?
If you're telling your landlord that, hey, this needs to be fixed, and they're not jumping on it. I mean, plumbing, you should have somebody over there the next day, or maybe even the same day. I mean, that's landlords, you want your rent. You got to act way above. You have to be so much more forthright than everybody else in our society, because we don't want to get ourselves a worse name. So you have to tell your landlord that, hey, I need this fixed now. And if not, you want to call up building and safety. They're going to come out there and they're going to cite your landlord for not taking care of a legitimate plumbing issue.
Okay, thank you.
So, my pleasure. Good question. Yeah, you know, it's not just enough that, you know, we talk about, gee, all the bad things that tenants are doing to us. There are some landlords that don't play the game correctly. Now, from the public's point of view, it's 95% of the landlords that don't play their game correctly. The truth is, maybe it's 0.5%, but talking to that 0.5% of landlords, you got to be on your game. If something's broken, fix it, because the alternative is that you're going to find yourself in a situation where you're getting cited, orders to comply, and it's going to be much more costly. I'm going to move on to Harold. Harold, please unmute yourself.
Dennis, that was so killer, the event that I went to.
No, thank you so much.
The only negative is there was not enough room. It was at standing room only. You need like twice the venue now.
Well, it was the Los Angeles Convention Center, but yeah, the turnout for my seminar was very packed. It was standing room only, but I'm glad everybody had a good time.
Yeah, so here's the question. We talked about last week. Somebody's too loud, you send him a couple letters. After he still doesn't comply, you send him a 3-day notice to quit. Does that mean on day 4 he's supposed to move out literally, or what is the action steps after that?
Well, the tenant is, if he's a nuisance, and you've given him a reasonable chance to act like a human being and he's not, then yes, we would serve, as we do in many cases, a 3-day notice to quit. At the end of the 3rd day, the tenant is supposed to be out. Well, in most cases, the tenant will not be out at the end of the 3rd day, and then we file an eviction lawsuit, an unlawful detainer, based on the theory of nuisance.
And then when you do that, at the same time, you guys will send paperwork to the city of LA. Does the city of LA do anything in response, or they just like keep records of what happened?
They just keep records. They're just
right. And they're the nuisance.
What you're referring to, Harold, is that the city of Los Angeles wants, anytime you serve any kind of a termination notice, you have to send a copy of that notice to the city with their eviction cover sheet filled out. And the only reason why the city does this, the only reason, is because they're hoping landlords don't, so that when you get to trial, you'll lose your case. It's just a tactic that the politicians have used. And it's not only the city of LA, unincorporated area of LA County, and a bunch of other municipalities use this as a guise, like, we want to see the notice. They're not doing anything with this notice. That's a bunch of hogwash. They just want landlords not to do it, so that defense attorneys can check on their records to see that it wasn't filed and therefore win their case.
Right. So let's just say we go to court How long typically does it take to go to court? And then after court, how long does it take to move this person out? In
Well,
the
we're
perfect
quoting
scenario.
about altogether about 2.5 to 3 months to have a tenant vacate. The main problem lately is that the sheriff's office, which is the next boondoggle in our system, is taking about 1.5 months plus to just do a lockout. So it's very unfair for landlords who have won their eviction case, and we get through the case relatively quickly, but we've won their eviction case, and now we're stuck waiting for the sheriff to do their job. So I'm quoting about 2.5 to 3 months, Harold.
Right. And yeah, so basically that's if they do their job, but in worst case scenario, it could be like 4 months, 5 months if they're not doing their job.
Well, they're supposed to, when in the olden days prior to COVID, and COVID has nothing to do with this, if I
Right.
delivered a sheriff, if I delivered a writ to the sheriff's office, they would post the 5-day notice the next week and they would lock out the following week. So a little bit more than 2 weeks gone. Now we're seeing it 2 months. This is insanity. I've had a couple of cases. I've delivered the paperwork to them in the beginning of February. They still haven't even gotten around to posting the notice. So the sheriff's office is in need of a lot of help, and they just raised their fees, but they might have raised their fees, but I haven't seen any results of that.
So do you think there might be some intentionality on that, or just?
I really don't know what that is. I've written a letter to the Board of Supervisors and to the head of the Sheriff's Department. I forget his name now. I think it's Luna. And I haven't gotten a phone call back. Anyway, thank you very much, Harold. Moving on now to, in order, Thomas Derbacourt. Thomas, I'm going to ask you to unmute yourself.
Hi, Dennis.
Hello, Thomas.
Thank you very much for organizing this forum. This is great. I have to say, I used your service for an eviction before and we're successful. So, and I'm grateful I'm able to also leverage your expertise like that. Here's the case I have right now. So I have a 4-unit in Los Angeles under rent control. Those are 2 bedrooms. And right now the issue I have, one tenant's not paying, or they're paying extremely late. And not only that, and the tenant has 3 kids that moved in that are not on the lease. I told her she'd be evicted if she doesn't pay the rent. It was a verbal conversation that didn't go anywhere. As far as their rent, they pay $1,600 a month. So here are my questions. For the 3-day, I read your tutorial on the 3-day notice, which pretty much said that there's no need to submit a 3-day notice until I think it's $2,200. That's the minimum due comparable for a 2-bedroom in LA.
No, it's more than that now. It's $2,560. I'd have to look it up. I'm surprised I don't have my chart up here, but it's about 2,500 plus right now.
Okay, so it means, I mean, technically with the $1,600 a month, it's almost 2 months I have to wait before I can serve the 3-day notice.
That is correct. Yes,
that's my understanding. Okay.
So well, wait, but right now, if they haven't paid you March, last time I checked, we've got April coming right around the corner.
Correct.
So we can do that right now.
No, March was 1,600.
Right, but now April's here. It's going to be 3,200. You're good to go, young sir.
Okay. All right. Okay, I get you. It's not prorated per day. It's at the beginning of the month. Okay.
You got it.
Thank you for that.
So that's coming up next week. We can start this eviction.
Okay, great. Then what about late fees? Question. I got 2 more questions.
By the way, before we move on, I got my chart up. It's for a 2-bedroom. It's 2,544. And a 1-bed 2,544 for a 2006. So ladies and gentlemen, what we're talking about is in the city of Los Angeles and unincorporated areas of LA County, you can't do an eviction. You can't serve a 3-day notice unless it exceeds the threshold. Let me do this real quick, see if I can get this up. And right there. There you go. You should be able to see that now. So for an efficiency apartment, it's 1,777, 2-bedroom, 2,544, 3 bedrooms, etc. So that's the list. And you can't serve a 3-day notice unless it exceeds that amount. So for Thomas, what you need to do is just wait till next April 2nd, we can serve a 3-day notice for both months.
Okay. And a couple of follow-up questions. One on late fees. So if you serve a 3-day notice and there are late fees as per the rent contract, the notice doesn't show the late fees. The tenant may come back and say, well, you didn't ask me for late fees. How do you recoup those late fees? Are they even relevant anymore?
Okay, well, first of all, assuming you have the proper language in your rental agreement,
Mhm.
and therefore you're entitled to late fees, you
Yeah.
cannot put late fees into a 3-day notice to pay rent or quit.
Yes.
But you can enforce your late fee provision by serving a 3-day notice to perform or quit.
Okay.
And that has nothing to do with this quote, fair market rent value. So if you have it where you legitimately can charge a $50 late fee, then in that situation, you can serve a 3-day notice to perform or quit for $50. If you don't get your late fee, you have the right to proceed forward with an eviction.
Great, thank you. And so answer to my third question, extra tenants, the 3-day notice to perform or quit, can it be submitted pretty much immediately? And
Yes, well,
does it
under
also have to be filed? And does it also have to be filed with the county, not only the city, but also the county?
Okay, first of all, is your property located in the city of Los Angeles?
Yes.
Okay, so it has nothing to do with the county, it has everything to do with the city. Anytime you serve a termination notice of any type, you have to also send that into the city. They have an online procedure, or you can just mail it in. That's number one. Number two, if extra people move into the unit, they're considered guests unless they've been there longer than 30 days, notwithstanding whatever you say in your lease. LA City says that they have to be there 30 days. So once they're there 30 days, we would then serve a 3-day notice to perform or quit, giving them 3 days to get rid of the strangers. If the strangers are still there after the 3rd day, we have the right to evict everyone from the unit.
Thank you very much. I appreciate it.
All right, Thomas, good questions. Moving along to Garber, I'm going to ask you to unmute yourself, please.
Hi, good morning.
Well, actually, I think it's the afternoon. Depending on where you are, you could be in Hawaii.
It keeps me awake just staying in the morning. I called you last week on the 602. Before I get into my question, I just wanted to correct you on something. When you were talking to a person earlier, you mentioned it was good for 30 days. With the adjustment that was made by the legislature this year, it changed to 12 months.
Okay, good.
And it can be longer in certain circumstances.
The only problem with that is which landlord's really going to do that unless they've heard this Zoom meeting. The landlord's going to come back to their vacant house and all of a sudden, who the hell are you in my house? So it seems like it's a good law, but no one's going to be doing it. That's the problem. Nobody knows about the law. But I guess if you are concerned, then hopefully the word gets spread that you
if I get a vacancy, what I'm going to be doing, or notice of the vacancy, while the notice period is running, I'm going to take the letter down to the police station. And then, what I'm doing on Monday is I'm going to talk to the on duty, what do they call it? When the person who's in charge.
I guess the desk sergeant or something.
No, there's another person. But anyway, if you go down ahead of time and you make them aware of this, and then so that you know what to do when you have to serve the notice or give them the notice, the 602 letter, before you actually have the vacancy, then you're able to, you're all set up for if anything happens.
Yeah, my point is which landlords are really going to do that except for you. If you do go down to the police department with your 602 letter, I would also bring a copy of the law with you and say,
that's exactly what I'm doing.
Yeah, so that this way they'll know. Listen, we do have to protect ourselves, and I'm not saying that what you're saying is not a great idea, because I think it is. I'm just questioning how many people are actually going to use it. In any event, did you have another question?
Yes, I have 2 people on a holdover month-to-month lease, and one has been paying the rent and the other does not work. If the one paying the rent dies, is their estate on the hook until the other person leaves the unit? And if
Well-
so, do I have to give the executor of the estate any type of notice?
Well, I mean, technically speaking, though this is never gonna happen, the estate is liable for the rent because basically a partnership rented the unit. And until the partnership leaves, then the estate would still be on the hook. I mean, so theoretically, you could file a claim, a creditor's claim with the estate on that, assuming that the other tenant doesn't pay.
And doesn't leave.
That is true. All right. Thank you very much, Garber. And we're going to move on to trying to get through all these calls today. And we might. Go ahead, sir.
Oh, yeah. So if I have two properties, one property, I want to do a 12-month leases, and then the other one, month to month. Would that be problematic if,
Well, what makes your criteria different for one person versus another? Why do you want to do a month to month on one and a lease on the other?
like in one property in one part, in one city, I might want to do Section 8, and that one I would have to do the 12-month. And the other one, I would rather do the month to month.
Okay, well,
Would that be problematic because one I'm doing on two different properties, not, was that,
no,
sometimes-
I hear what you're saying, but if you're going to try to avoid taking Section 8 by just doing month to month, you got to do it across the board for all of your properties, because otherwise it looks like you're trying to discriminate against Section 8. So during my speech, I did talk about the fact that Section 8 will not
Yes.
approve an applicant if the landlord's only offering a month-to-month rental
Mhm.
agreement. So if you want to avoid Section 8, issue demand only month to month, but you got to do that across the board to all of your tenants.
Oh, okay. Another thing, if I am willing to take Section 8, but can I, besides, I know I can't go based on credit, but can I say I will rent to Section 8 that has had a history of renting other properties? I want to go see. I can't check their credit, but I can go see how they live and how verify.
Well,
their
but yeah,
rental.
but you'd have to do that for everybody, not just Section 8 people, because otherwise it shows you're discriminating against Section 8 people.
Oh, yeah, that would be for everybody. So I could do that for everybody.
For everybody, correct.
And I could say, I'm not gonna rent somebody that just got the voucher and they got the $400 in their pocket, but I want somebody with history that shows that they're taking good care of the property.
Again, if your procedures are
For everybody.
for everyone, you're okay. By the way, were you at the convention center?
Yes, I saw you at the convention.
Yes,
saw
I thought you looked familiar. Anyway, nice talking to you, DC. We are going to move on to Jacob Lyons. Unmute yourself, please.
Yeah, hi, Dennis. Can you hear me okay?
I hear you fine, thank you.
Great. I have a fourplex in Burbank that I've inherited from my father. And I've also inherited a tenant who has been there for over 20 years. And his rent is way below market. And he, over the course of 20 years, he's become elderly and disabled. So a couple of questions pertaining to that. One is, in Burbank, are there limits on how much his rent can be increased? And so, sorry, let me back up. He's actually month to month, not on a lease. It's been month to month for over 20 years. So are there any restrictions on how much his rent can be raised
Well,
annually?
Burbank currently does not have
Burbank,
rent
yeah.
control. So you're under what they call statewide rent control.
Okay.
And that's an 8.8% rent increase. But your medicine to solve your problem is to do a renovation eviction, where you're going to renovate the unit, which you'd probably have to do anyway. And then we have the right to evict the tenant. You're going to need to pull permits under the new law. So basically, you're going to redo a kitchen or a bathroom or both. You're going to pull an electrical or a plumbing permit. You're going to have a contractor that will give you the scope of the work, showing how the premises will be uninhabitable for over 30 days. Have those two documents in your hand, the permits and that scope of the work, and contact us, and then we'll be able to serve on your tenant a 60-day notice to get out. You are going to have to pay relocation, which is 1 month's rent. And then you'll fix this place up. So get off the phone now, get your contractor on the phone. And that's a wonderful way to get your property up to a market level. Now, we don't know where this renovation law is going to go. There's been some threats in Burbank, believe it or not, which is where my office is, to clamp down on this. So we want to do this yesterday.
Got it. Okay, so you effectively answered my second question. I guess my follow-up really quickly is that, is any of this complicated by the fact that he's elderly or disabled?
The answer is right now, makes no difference.
Got it. Okay, that's fantastic. Thank you very much.
All right, thank you, sir. Let's move on to Richard. I'm going to ask you to unmute yourself, Richard. Are you there? Oh, I think I messed you up, Richard.
All right.
There you go.
Hey, Dennis. I just wanted to respond to the previous caller in regards to the notices that get sent to the city when it's a 3-day notice to perform or quit or pay rent or quit. For some reason, I had the impression that his question was, what does the city do with when they're notified? And I always wondered if they notify the tenants of their options of legal aid assistance or free attorney services, and that warning they should take this notice seriously and act on it, or some kind of notice that gets sent to the tenants, or not.
I'm not aware that the city does anything with it except to organize it. And if you use their online form, then you're doing their work for them by you're entering it into their computer system. So when the tenant's attorneys call and say, hey, did they send this in? And if they say no, then they'll quickly write a letter that they'll try to use in a court of law. But you just got to follow the law on this. Why that should be the criteria to win or lose a case, it just is what it is. And this also applies to so many municipalities. It's crazy, all the municipalities that also require that you mail stuff to them.
Got it.
In fact, well, actually, I don't have that up here. But there's the list is from Bell Gardens, Baldwin Park, Beverly Hills, Cudahy, Culver City. The list just goes on and on and on. So anyway, thank you very much for your question. And we are going to...
I did have one question.
Okay, go ahead.
That was just a response to the previous caller. I got one question. I do not include appliances in any of my rentals. For obvious reasons, I don't care to become the Maytag man. However, sometimes previous tenants, they may leave behind working stoves or refrigerators. I let the incoming tenant know that the rental unit does not include appliances, and I let the new tenant know that the appliances in the unit were left by the previous tenant, and that they will be loaned to them if they can use them. If they can use them, I'll remove them. If they can use them, I'll loan them to them till such time that they become inoperable or until they get their own, and that there is no warranty under the lease agreement on loaned appliances. I've been doing it for a while. I've never had an issue. I don't currently have an issue, but what's your thoughts on if it's on the lease that there's no warranty, it's a loaned appliance, the rental unit does not, their rent does not
I get the question. Let me answer because I'm trying to get through here. The answer is, as long as it's in your rental agreement that this stove or refrigerator was left as an accommodation, it's not part of the tenancy, and any repairs will have to be borne by the tenant. And the tenant also has the option of saying, if you want me to dispose of it right now, I'll dispose of it. So as long as that's in your rental agreement, Richard, you're golden. Thank you very much. I'm moving on to see if we can get through 2 more calls, and then I think I've run the table here. I'm going to ask Leslie to unmute themselves. Leslie?
Hi, thank you, Dennis. Thank you for this.
Leslie, I can't hear you, darling. I'd like to hear. Unmute yourself, Leslie.
Mute audio. there we go. Sorry, I unmuted it in one place and not the other. Anyway,
I can barely hear you. Speak up, darling.
1 sec. Let me turn the volume up. Is that better?
Sure, go ahead.
Great. My problem is I have a single family home that is in corporations that I inherited and I did it as a 1031 exchange from New York to California. I have an elderly tenant in there now, and I'm trying to take it over for myself. I spoke with a gal in your office and she said, you can't do it unless the house is in your name. But because I'm up against taxes and the 1031 exchange issues, I can't quite put it in my name yet. And I'm trying to strategize how I can get this single family home back to me so I can renovate it, move in, fix the other property, and eventually.
Okay, so here's what you can do. Number one, if the property is owned by a corporation is not moving in, okay?
Right.
So just logically speaking, that it can't be that if it's a corporation. Now, if you read the statewide rent control, it says that single-family homes are not under rent control unless it's owned by a corporation.
Correct.
So, but quite frankly, that's hogwash. The statewide law is hogwash because there's another law, Costa-Hawkins, which they're trying to throw out in the state of California, but under the Tenant Protection Act, which is coming up on our ballot in November, make sure you vote no against the Tenant Protection Act. But under Costa-Hawkins, it states that a single family residence, a condo, or a townhouse, there can be no rent limitations. So we have two competing laws, which states the statewide law says that a corporation, single family home, no, you're under statewide rent control. But this is why Costa-Hawkins controls, because the way Costa-Hawkins law is written, it starts with the following phrase: notwithstanding any other law, a condo or a townhouse or a single family residence is not subject to statewide limitations. So on that basis, I say the hell with statewide rent control, AB 1482, Costa-Hawkins controls. Now, for your situation, raise the rent. And
I'm raising it, but I did it by law of LA City because it's here in LA City.
But there is no rent control for LA City. Okay, for a single family home, you can raise the rent to market level. So even though you gave one rent increase, you can do another one now. Go to rentometer.com. That's RENT, the letter O, meter, METER.com. Plug in, they do 5 for free. It's a wonderful site. Plug in your address with the type of unit that it is and how many bedrooms and bathrooms. They'll come back with a comparison for that, and you'll be able to see what comparable rents are. You raise that rent to market level with the hope that the tenant will have to vacate. The worst that happens is he doesn't, and you got a bunch more money in your pocket. I'm going to move on. Thank you very much.
I still can't take it back is the point.
You can't take it back on the basis that you are a corporation, unless you want to sell half of it to yourself.
That I'm willing, I might do. Okay, thank
Then
you.
you can do that. Okay, last call of the day. We're going to pick on Paul. Paul, say hello.
Hey all, thank you. Hi Dennis, thank you for having these. I'll try to be concise. I have a family member who was given permission to live in my mother's home, but it's a little bit unique by comparison to everyone else. There's no lease and there's no rent. Now my mom would like to sell her home, and the family member isn't making any effort to move out and is actually damaging some of her personal belongings on the property in Altadena. What kind of notice do I need to serve to this family member? And is there anything specific that is required in that notice telling him to move out?
This person does not pay rent, correct?
Correct.
This is a tenancy at will, it's called.
Okay.
It's a special 30-day notice to quit that needs to be served on, and the special language that needs to go into that notice. Generally, people use the services of an attorney like my firm to do that. But you have every right in the world to proceed forward with an eviction based on that. This person has no, quote, tenant's rights because they're not a tenant. They don't pay rent. So
Got
if
it.
you want, you can call our office, but it is under the theory of a tenancy at will, Paul.
Okay, thank you. Appreciate your time.
No problem. Well, ladies and gentlemen, we have come to the end. Actually, we're 7 minutes over. And I've got a date in Beverly Hills at Mr. Chow's tonight with my daughter and wife. But we're going to be moving along. I appreciate everybody who's come out. I will have this on YouTube and I'll have it edited and sent up. So I do appreciate everybody's time. Guess what? Next Saturday, I'll be doing this again. And again, it's every Saturday at 3 p.m. Appreciate everyone and everybody stay safe. Love you all.